Good morning, everybody, and welcome to this morning's webinar giving you an employment law overview of what's new and happening. Just getting set up here. Hopefully you all can hear me loud and clear. Today I'm joined by my colleague Jennifer Huzzy, who's worked with the source software BrightPay for the last 20 years, so definitely knows a thing or two about payroll and HR.
Morning.
Employment law itself is such a wide topic. We would need a day to get through the basics of it, never mind the hour that we have this morning. So this morning we just wanted to discuss what's new in employment law and what's really topical. We look at some of the news cases that we've seen of late, and we'll have a little look at some of the FAQs, the frequently asked questions that we get through to our support line, and we'll finish off giving a brief overview of where BrightContracts is handling all those things that are topical, I suppose. As always, we'll have our Q&A session, which as always kind of can be quite interesting. We'll have that at the end, but please do type questions in as you think of them. And finally then, just to say that we are recording this morning's webinar, so you will receive a recording of it if for any reason you want to pass it on or need to leave early or want to re-listen to it this evening when you're doing your ironing at home. So that's the agenda there. We've put it up there, but without further ado, we'll get going on what's new. I suppose 2018, it's again set to be another busy year for employment with many kind of significant changes in the pipeline. The end of last month, we saw the end of the Fit for Work assessments. April, again, is as always, is a busy year for kind of tax-related changes. May then sees the introduction of the hugely anticipated and slightly feared GDPR, the General Data Protection Regulation. And then looking ahead back up to October, we have the abolition of childcare vouchers. So we want to go through into each one of these in a little bit more detail and to discuss how they will affect us as employers.
Okay, so the first thing we're going to look at then is the Fit for Work assessments. So it was announced back in December that the Fit for Work assessment scheme was going to be scrapped. It was launched only 3 years ago, and it consisted of a kind of free information service that provided advice on health, work and managing sickness absence for employers. And it also gave a free occupational health assessment service for employees who had reached or were likely to reach 4 weeks of sickness absence. And under the scheme, most referrals were expected to be made by GPs, but employers were also able to refer on employees. The Fit for Work helpline and the website for the workplace health and advice and support on the sickness absence are still available, but from 31st of March they're just gone in England and Wales, and from the 31st of May in Scotland, the actual assessment service itself will cease. Now, the closure of the scheme has been attributed to low referral rates. A recent survey by the GP magazine last summer found that 65% of GPs had not referred a single patient to the Fit for Work service, and that a lack of publicity was the reason or the causing for that. So the scrapping of the Fit for Work assessment has come as the government announced ambitious plans to get 1 million more disabled people in work over the next 10 years. So on the back of that, there's a new service coming into effect called the Disability Confidence Scheme. And this is going to support employers to make the most of the talents that some of their disabled employees can bring to the workplace. And so far, more than 5,000 companies have actually signed up to this new Disability Confidence Scheme. So if you haven't heard of it, you'll probably hear more of it coming up in the next few weeks, but it certainly is something to look into for your own business.
It's a useful website, so do look into it, and it gives tips and hints and ideas as to how you might look at bringing disabled people into your
the workplace.
Okay, so then minimum wage is always generally 1st of April, minimum wage increases, and it did this year. So workers aged 25 and over, the national living wage, that's gone to £7.83. Workers under 25 but over 21 and over, should I say, it's £7.38. The development rate for workers, so 18 to 20, it's £5.90 per hour. Young workers rate, so those aged 16 to 17, it's £4.20, and then the apprentice rate is £3.70. So I'm sure we're with start of April now, but if you haven't already updated, or if you're running payrolls for last week or whatever, you need to be just looking and adjusting your minimum wage rates. Other changes in terms of increases to rates will be, we've seen some increases to the statutory rates of statutory maternity pay, paternity, adoption pay, SAP, and shared parental pay. So these have risen from £140 to 145 a week from April. And also we've seen an increase in SSP, statutory sick pay, and that's due to rise or has risen from £89 to £92.05. And also the lower earnings limit as well, which should definitely be used in pension qualifications, has gone from £113 to £116. So just to be aware of those rates as well. Okay, so I guess unless you've been living under a bus for the last week or so, you'll be familiar with that, the gender pay reporting, and we had our deadline last Wednesday, the 4th of April. So employers with over 250 employees had to publish their first set of reports last week. So in that deadline, over 10,000 companies filed their gender pay report, and it's revealed some interesting statistics, I think, right across the board. Overall, I don't know if we have anybody with over 250 employees on our webinar today. I doubt it, but I suppose it's just interesting reading anyway. Overall, 78% of those companies, of the 10,000 companies that reported their gender pay reporting, so 78% paid men more than women on average. The average hourly pay gap across all employers was 18%. And there's some, again, interesting reading that the largest pay gap was 85%, and that was from the NWN Media Group, which was a regional business group. And then, of course, I think Ryanair was in the news as well. I think their gender pay gap was up in 60%. And their argument was that I suppose a lot of their pilots are men, and a lot of their flight stewards would be female. But that kind of is the crux of gender pay reporting for me, because it's not about equal pay for equal work. It's about, well, why don't we have women in those more senior roles, in the roles of pilots, and for companies and I don't know, the business world in general to be looking at how we can promote those positions. So for companies who didn't publish a gender pay report, they will be investigated. They may receive a court order, and they could receive a fine as well. Now, originally, fines weren't introduced as part of the gender pay reporting requirements, but I think as there's certainly a quite significant percentage of companies who haven't filed, so they may be looking at the Equality and Human Rights Commission, the EHRC. They may be looking at bringing in more significant fines in that regard. I can kind of go back to the whole aim of the gender pay reporting. The aim in the legislation is that through publishing and monitoring these pay gaps, employers will understand the reasons for any gaps, and they'll look to consider whether they need to develop action plans to tackle the causes. And whether that is something as, you know, changing your job descriptions and making them more appealing to both sexes, I suppose, when you're looking at the more senior roles as well. So it's an interesting topic. It's just coming to the fore with the deadline last week, and it'll be interesting to see where it goes from here, and what's the knock-on effect next year when we look at the gender pay gaps next year, when people start reporting them as well.
Exactly. The next thing then we want to look at is your pay in lieu of notice, or pile-on as we like to call it for short. So changes to the way in which termination payments are taxed is coming into force, or has come into force from the 6th of April. All notice pay is to be treated as earnings and subject to tax and NI contributions, irrespective of whether or not there's a payment in lieu of notice clause or pile-on clause in the employment contract. This effectively removes the distinction between contractual and non-contractual pile-on. As a matter of best practice, we generally certainly recommend that all contracts contain a pile-on clause. And at this stage, there's no reason not to have it. And really, from an employer perspective, it is beneficial to have that little bit of flexibility in place there when it comes to the employment contracts. And realistically, in fact, not having a pile-on clause now will only leave you at a disadvantage if you're to make a payment in lieu of notice without the contractual right to do so. It risks not being able to rely on any post-termination restrictions, such as the likes of non-competition clauses and confidentiality. And this is because you would be in breach of the contract by making the payment, and therefore you can't rely on any of the other contractual clauses that you may have in place as well. So you need to bear that in mind. The next one then we're going to look at is the employment allowance. So the government plans to introduce a deterrent to the employment of illegal workers. So from April of this year, employers will not be able to claim the employment allowance for 1 year if they've hired an illegal worker, if they've been penalised by the Home Office, or exhausted all appeal rights against a penalty that they've already been given. And I'm sure most of you will know, once you qualify for that small employer's relief, the employment allowance gives you a reduction of £3,000 a year on your employer NIC contributions, and for a small company that's a massive benefit. So it certainly does highlight the importance of getting the onboard process correct for new hires, making sure you have the proper work permits in place, or the employees, so that you avoid any unnecessary fines later down the line. You have to ensure all employees have the right to work in the UK itself. Okay. Next, then we're going to look at a week's pay. So the method used to calculate statutory redundant payment is known as the week's pay. And the maximum amount for the week's pay is increasing from £489 per week to £508 per week. So if you were to make an employee redundant on or after the 6th of April, the weekly pay is now capped at that £508. And the maximum statutory redundancy pay you can get now is £15,240. So just that's increased from the 489. And then your tribunal awards. So the maximum compensatory award for unfair dismissal has increased from 80,541 to 83,686 once the date of termination is on or after the 6th of April. And the topic of tribunal cases and awards is very topical, with the abolition in the last year of the tribunal fees. And we're going to touch on this a little more detail later on. But what is interesting in relation to the unfair dismissal cases is that for the last year that we have full stats available for, which is 16-17, the highest sum awarded in a tribunal case was £1,744,575. And this was actually awarded in an unfair dismissal claim. Now, usually the honour of the highest award goes to discrimination cases, where there is no cap whatsoever on the amount of compensation that can be awarded. However, this 1.7 million was awarded in a case, or must have been awarded in a case where the cap actually doesn't apply, which is in the likes of a whistleblowing case or a dismissal for raising a health and safety issue. But on average, where awards are made in unfair dismissals, it's usually in and around 16,500 as the figure for that.
Perfect. So I think that brings us to the end of April and brings us up into May, which is the GDPR. And at this stage, I'm sure you're all well familiar with what the GDPR, the General Data Protection Regulations is. And it's coming into effect in May, so the clock is definitely ticking fast now. And I suppose the general intention of the GDPR is to put stricter controls in place around how we process personal data. The GDPR will have a direct impact on how we manage our employees' data. So we're just looking at it here from an employment perspective. Employees' data that an employer would hold could be anything from their name, their bank details, their NI number, their medical records, performance records. So it's quite a broad spectrum, and it's not just your employees. It would cover if you've just been through a recruitment campaign and those CVs that you brought in of unsuccessful candidates as well. Now, certainly today is not a GDPR webinar, but we do want to touch on some of the main ways that GDPR is going to affect HR or simply the management of your employees if you're in a smaller company and you don't have a specific HR department. So I suppose the first thing then is to talk about is relying on consent for setting clear reasons for processing employee data. Getting consent from an employee to process their personal data was the option that we all took under current data protection legislation, and we're all used to putting in a data protection clause into the contracts of employment, which is kind of almost like a catch-all clause, but it just says to employees, we'll use your personal data and then you're kind of covered. However, that's not going to be the case anymore. Under the GDPR, consent must be freely given, specific, informed and unambiguous. And those are the words of the GDPR. So then if we put that into an employment perspective, there's an imbalance of power between employees and employers. So the power is generally with the employer when they're hiring somebody. So in that situation, it will be difficult for an employee to give consent freely. So we can't rely on consent for legally processing employee information anymore. So then what are the reasons? As an employer, then you have to step back and say, well, why? In order to process any kind of data, you need to have a lawful reason. So you need to set out what your lawful reasons are. And that could be, in an employment perspective, what we tend to be looking at would be the legitimate interests of the business. So it would be, in order to run your business, you will need to have possibly performance records so that you can manage employees. It'll be for the performance of a contract. In order to comply with to have a contract of employment, you'll need to have certain information, and in order to be legally compliant. So you'll need to have certain information regarding payroll details, so you can legally pay an employee. So these are going to be the reasons that you're relying on in order to process your employee data. So what you're going to need to do is, once you decide on these reasons, you're going to need to process, you're going to need to communicate that to your employees. And that's another really important concept of GDPR, is the transparency, the communication, and being clear. So when collecting, and the GDPR requires that when you are collecting personal data, that you provide this information to the individuals in question. The data subjects is how the GDPR refers to them. In this case, your data subjects are your employees. So once you decide on what data you hold, why you're holding it, what are those lawful reasons, and you need to decide on things as how long you're going to hold it, it's going to be really important that you communicate that to the employees. So that means you're going to have to look at your data protection policies that are in place for employees, and possibly a new document. The way I would see it is a new employee privacy policy. So often we see privacy policies on websites, and they're down the bottom in the footer at the bottom, and there'll be a privacy policy that a company has put in place for their customer data. I see now we're going to have to put that in place, an employee privacy policy that sets out what you're going to do with your employee data.
Absolutely. Now, Laura's touched there on the, kind of data that you may hold and the reasons for processing data. And one of the things she mentioned there is if you have a recruitment drive. So every recruitment drive involves gathering information on candidates and checking that they're fully suitable for the job in question. But once that recruitment process has ended, the data of those unsuccessful candidates will no longer be relevant. So employers will have to ensure that this information is not retained for longer than is absolutely necessary. And you really need to look at, kind of designing policies that make certain this pre-employment data is disposed of safely and securely. So again, in your privacy policies, you need to be sure that you address the likes of your recruitment candidates as well.
Okay, so then moving on, GDPR states that organisations can only hold on to data for a certain period of time, and it's a whole concept of not holding on to data for longer than you require. So we talked about earlier, you're going to need to decide how long you hold on to your employee data. Fortunately, I suppose, with regard to a lot of employee documentation that we hold, we can be led by legislation, because there's a lot of information, for example, in the Organisation of Working Time Act, and that gives guidance as to how long you hold records of annual leave, etc. So in terms of once you decide how long you're going to be keeping your employee data for, be guided by the legislation. Obviously HMRC have guidelines then in terms of how long you keep payroll records, so you'll be guided by legislation. In some areas there's no legislation, and that could include your performance records, so you need to make a business decision as to how long you keep employee performance records for as well. And then, just as Jenny said, you need to be removing them safely and securely in that time frame, once you've come to that time frame.
Exactly. That's a question that comes up quite regularly on the helpline as to how long, certain data needs to be kept for. And I suppose the statutory obligation is always going to override, anything else.
And in some cases you may decide I need to hold on to data. So payroll data would be 3 years. HMRC may have, for some reason, if you have a strong business reason to hold on to it for longer, once you can justify that strong business reason, that would be okay, but you have to have shown the thought process behind it.
Yeah, and the accountability for it, exactly. The final thing there in relation to the increased rights. So the GDPR has significantly enhanced the rights of data subjects, for example, your employees. So firstly, with regard to the right to information, employers will need to be able to provide more detailed information as to how and why the processing of HR-related personal data is there. So again, kind of touching back on the privacy policies, this is quite a long list of information that needs to be provided and aims at giving more transparency, as Laura said, to the processing of data. And also by doing so, that enhances your security. So in this regard, under the GDPR, employers will need to be giving their employees a detailed privacy policy outlining how and why their data is being processed. Secondly, employees have a right of access to their data and a right to have inaccurate or incorrect data rectified. These are existing rights but have been modified to bring more clarity to the rights that are there, but they're not extended that much. And what is an interesting development in this regard is that the GDPR has recommended that where possible, employers provide their employees with a self-service facility where employees can actually log in and view their personal details, whatever you may have on file. Now, it may not be possible in all workforces, but really should be something employers consider putting in place if they want to put their best foot forward in terms of the GDPR compliance. And we look at our BrightPay Connect option, which is our kind of remote portal that you can use. And then finally, under the new so-called right to be forgotten, employees will be entitled to require the employer to erase personal data about them in certain circumstances. Now, this may be the case where the data is no longer necessary for the purpose for which it was originally collected, or where the employee has withdrawn his or her consent. So on that point, again, we'd really suggest that companies have a clear data protection policy in place so you don't find yourself having to delete data prematurely and find yourself in breach of other aspects of the GDPR.
Perfect. Just to pick up on something that Jenny's been talking about there is the new recommendation to have this employee self-service option. And I think it's not legislation under GDPR, but it's a recommendation. And if you're in an employment, if you're an employer and you're looking to put your best foot forward in terms of GDPR compliance and really looking to make the correct moves, I suppose, if you like, looking at an employee self-service option would be really would be key to that. So I just want to show you why and what it can offer, and I'm just going to show you a few screens of our BrightPay Connect and how it offers. I've logged in as Carla Byrne here, and Carla has logged in securely into her own self-service login, so it's totally secure to her. Carla only sees this, but what Carla can see here is she can see all her old pay slips, and she can see her basic information, and she can actually update that information. So Jenny has been talking about the right to modification or the right to update your details. That right, or the onus on having correct information and correct employee up-to-date information, is on you, the employer. And if you as an employer were to send out, let's say somebody's on long-term sick leave or they're gone for a long time, and you send a letter to their home address as you have it, inviting them to a meeting, and you don't ever get a reply, and in the heat of the hunt it appears that you've actually sent it to the wrong address because they've moved on, that's your responsibility, and it's your fault that you didn't have the right information. And you should have made steps to ensure your information is up to date. So by having options like this, where you're putting the onus back on the employee to keep you as an employer informed, you're only protecting yourself from a GDPR perspective, yes, but also from an employment law perspective. I think that's a really key feature that you want to look at. And equally, going off tangent and picking up on this, keeping your employee records up to date, a really useful clause is to have that in your contract of employment as well. So it's a contractual term that the employee has to update you when their personal information changes. So that's just one aspect of it. Again, here the annual leave, so Carla can put in annual leave requests here. They can be approved at the touch of a button by her manager, so really, really easy to use. Also, what Carla can do, as I said, she can go in and she can see all her pay slips for auto enrollment letters. And we're in 2017 now. Obviously, if we're in 2018, Carla will still be able to go back in and see 2017 pay slips. And even from my own point of view, in a HR role, that stops. Someone's going for a mortgage and they're coming to you looking for their last 3 months pay slips. I don't get those requests anymore because the employee can go in and they can log it, or they can see it. It's totally transparent. And just to follow on the whole transparency issue, our BrightPay Connect has a document upload feature, and here you can upload any kind of document for an employee. So we have examples of the contract of employment. It might be an individual probation extension letter. So it's effectively your employee's file in the cloud, and the employee can log in and view that at any time.
It's something actually, Sarah, just while you're on it, we do get the comments again, kind of from customers back, like the administration headache when you get that request in for the last 12 months worth of pay slips, for a mortgage request. And, if you've got a workforce of 50 people, you're guaranteed you're going to get at least 1 or 2 a year.
Yeah.
The admin headache of that is all taken care of. And again, the onus has been put back on the employee. So you're pushing a lot of buttons in the right order.
And I don't know if we have any bureaus here today, but equally, if you're a bureau offering this, and your client's employees will be able to access
it directly again. So you're cutting out the middleman as such. Yeah.
So it's a great, something really useful to consider. Perfect. So we'll move on then to, where are we now? We've passed May and we're gone to October in our year schedule, I suppose, and the changes to the childcare voucher. So this was due to come in around now, April time, and the government pushed it back to change it in October. So they're scrapping the childcare voucher scheme as we know it and as it runs through payroll, and they're introducing a tax-free childcare scheme which enables parents to receive a contribution from the government of 20% of their childcare costs, up to a maximum of €2,000 per child. And how it works is that parents can open their own childcare accounts online, and then the scheme is not led through the employer. It's totally separate to your employment, but the government can top up the accounts online. I think part of the reason why this actually was delayed is because there's been a difficulty with parents setting up those accounts and getting the funds in from the government. So we'd wait to see actually whether or not it will come in. It's very much still in the balance of will it be brought in come October time, but that's where we're moving towards. The point to note, I suppose, with the changes to the childcare vouchers is that if you have a childcare voucher scheme in place at the moment, you can continue using it post-October for existing members only. So you won't be able to allow any new entrants into the scheme, but certainly you can keep it going for existing employees. Whether or not an existing member of the scheme is better off in the childcare voucher or using the new childcare scheme, it's not for us to say. It'll definitely depend on the employee's own personal circumstances, I suppose. But that's coming down the line in October, as we said. So that brings us through the 2018 changes and the calendar that we saw at the start. So now we just want to look at a few of, well, what's been in the news, I suppose, of late.
Exactly, yeah. So there's quite a few topical HR issues that have been in the news headlines of late. We're going to look at just a couple of them. So the first one then is your tribunal cases. So obviously the abolition of the tribunal fees has now shown a massive 90% increase in the single claims lodged at employment tribunals in the last quarter of 2017 compared to the last quarter of 2016. And that follows directly from the Supreme Court ruling that the tribunal fees were actually classed as unlawful and abolished them from that point. So with the abolition of the fees came a refund scheme. Now the refund scheme so far has seen just near on 3,500 claims processed for refunds of the fee payments, and that's been valued at nearly 3 million, and that's just for that period of October to December last year. There's 4 years worth of fee payments that actually could be claimed for, and that's just adding to the growing headache that is the whole tribunal fees debacle. And I'm sure you're all aware this is going to put, and it is putting, significant pressure on the tribunals who had, after the fees were originally introduced, reduced their staff numbers and had their funding cut. And they're now having to deal with these huge backlogs and delays because they don't have the resources to actually deal with it. And the increase in the employment tribunal claims since the removal of the fees indicates just how important it is for employers to have your proper policies and your fair procedures in relation to your employee-employer relationship. So it is paramount that they are up to date and you use them.
Yeah, if you don't have your disciplinary or the proper policies in place, and then you're the likelihood or the chance, you've got a greater chance of coming in front of the tribunal now,
front of them.
and you won't be in any way it'll be difficult to defend any cases without that documentation.
Absolutely, absolutely. Laura touched on the gender pay reporting earlier, and Tesco's have found themselves in hot water. Tesco always seems to be in the news. But they found themselves in hot water in relation to equal pay claims. So the supermarket could be in line for a £4 billion equal pay claim for up to 200,000 female store workers who are alleging that they're being paid up to £3 less per hour than their warehouse counterparts, which generally tend to be men. Now, although it's not the only pay discrimination case by a supermarket chain in the news, this claim, if it is upheld, could have the potential to be the highest value case of pay discrimination in the UK history. The equal pay legislation states that men and women are entitled to equal pay for equal work. This work can be like work that's the same or broadly similar, work rated as equivalent in terms of the job evaluation scheme, or work of equal value that is equal in terms of the demands made by reference to factors such as effort, skill and decision making. So the Employment Tribunal will have to appoint more than likely an independent adjudicator or an assessor to find, to kind of assess whether or not the jobs are of equal value. I'm looking at things like the nature of the work, the experience of the employees, the responsibility that they hold, the communication, knowledge, working conditions, and that list could go on and on. Morrison's and Asda and Sainsbury's are also facing similar legal challenges over equal pay at the moment, but £4 billion is a huge amount of money, and really just kind of does put into focus that these high-profile equal pay cases and the gender pay gap reporting deadline really need to have employers looking at their own businesses to see if you've got any issues or risks that you need to consider and what steps you need to take to reduce any possible damage that could affect you later on.
Perfect. Okay. We talked about minimum wage, and you're probably aware of the government's, the Department for Business, Energy and Industrial, their name and shame operation that they've been running, I suppose, for the last number of years, where they name and shame employers who are found guilty of not paying minimum wage. So they released a new report there recently, and from that report, the hospitality, hairdressing and retail industries were top of the list of the worst offenders. Again, I must look at our attendee list and see if we have anybody in those industries with us today. If you are, you need to be checking that you're not on that offenders list. The restaurant chain Wagamama actually topped the list for individual employers, and they underpaid a total of 133,002 employees. TGI Fridays was near the top as well, and it was just shy of 60,000 that they had underpaid their employees. So in addition to having to pay that back pay for the out-of-pocket employees, these companies would have been fined as well. And really, I suppose you would think that these large firms would be able to pay minimum wage, and why weren't they? But some of the reasons that were given for falling below the minimum wage include charging staff for uniforms or expecting them to fund their own uniform independently, and failing to pay overtime, and then issues around job-related travel expenses. So I think just that brings up an issue for me just around the whole staff uniforms, and can an employer require employees to pay uniforms? And the answer actually is yes, an employer can require an employee to pay for their own uniform as long as there is a contractual provision in this. So I don't think Wagamama's had a contractual provision. The only exception to this is for personal protective equipment, which would fall under, health and safety reasons. So if an employee needs steel cap toe boots or something for working in a kitchen, that's a health and safety requirement, it's a protective piece of equipment, then you cannot charge them for that. But certainly you can charge in terms of uniform, or you can ask employees to pay for their own uniforms as long as there is a contractual cause for this. And I think actually with Wagamama's, I'm not sure if it was Wagamama's or TGI Fridays, their situation was it wasn't actually a uniform, but employees were required to wear all black or, you know, the company colours. So just be mindful of that as well. And I suppose just the learning points from these cases, if you are an employer who is paying close to minimum wage, is that you just need to be particularly careful that you don't inadvertently, it mightn't be that you've done on purpose, but is that you don't inadvertently breach the law. So for example, even requiring staff to arrive in early for their shift, or time spent in meetings. If you're asking people to come in the evenings for a meeting, that could be seen as working time, and that could then in turn lead to an underpayment of wages. So you just need to be aware of that. And I suppose just then the final point of this that comes up, we get a few questions. Additional payments such as tips, premiums for working unsociable hours, they should not count towards minimum wage, so they will be separate. Okay, another topical issue, I suppose, has been in the news of late. Obviously it's come from Hollywood, but there's been local stories as well, is the whole issue of bullying, harassment and sexual harassment. And I suppose really when we speak to people on the phones, they are words that can strike fear into the minds of organisations, and they just hope it never comes on their door, I suppose. The first thing to point out in relation to this whole area is that it is covered in the Equality Act 2010, and there is an obligation on employers to prevent harassment in the workplace. So it is vital for companies to be mindful of this legislation, as there are, you know, you as an employer will be answerable if an employee, a supplier, or even a customer was to become a victim of bullying or harassment. And I suppose just to give a few kind of facts and set the scene around bullying and harassment in the UK workplace, and just to show you it is an issue. And according to a 2016 NHS report, 22% of NH doctors and dentists experience bullying, harassment or abuse from other staff. The television industry and the media, not only are they up for gender pay reporting, when we've seen that earlier on, they're also another industry which has come out not so well in relation to bullying. Again, another report showed that 315 media workers revealed that of 315 media workers that were researched or reported on, 2/3 of them had been bullied in the workplace. And then on top of that, we've had really recent reports of extremely high levels of bullying and harassment in the House of Commons, which is just awful and extremely disheartening. And so I suppose this is where we see that our democracy is to be kept open and fair. And when we see it there, it's a bit disheartening. But just actually to give you more of an example of a case, Primark, they had there was a situation in the high street retailer Primark where they had a transgender female who had been a transgender female for over 16 years, but they were subject to continuous harassment by colleagues, and the employer didn't do anything to deal with it. So the court found in this situation that this individual had been constructively dismissed and that her treatment violated her dignity and created an intimidating, hostile, degrading environment for her to work. She was awarded £47,000. So that was quite a significant award. When we're looking at unfair dismissals earlier, and Jenny saying the average award is 16,000,
yeah.
Apologies. So when you're talking about bullying and harassment, you can see there's quite significant awards that are awarded. So it's important to get it right as an employer.
And just on that, actually, that 47,000 was actually made up. 25,000 of that was specifically for the injury to her feelings, as opposed to just loss of earnings and pension. So just on from that then, what is bullying and harassment? It can come in a huge amount of forms. So you're looking at the likes of social inclusion or isolation, any form of intimidation, so you've got to be very mindful of your workplace, trying, if you can, not allow the likes of little cliques or little groups to, kind of get started or accumulate. And then repeated requests for unreasonable tasks to be carried out, and that can be deemed as a form of bullying or intimidation from management or from higher up. So, it does come in many forms. You just need to be very aware of it. And because as Laura said, you are responsible for ensuring it doesn't happen.
And actually, the Equality Act, talking about it being covered in the Equality Act, it defines harassment can be a once-off event. So it can just be literally a once-off event. It doesn't have to be something that is ongoing. So I suppose, anyway, the question out of all of that is what can you do as an employer? So in terms of how you prevent bullying and harassment in the workplace, key to this will be to build a culture of non-tolerance. And that's very important that that comes from the top management down. You'll also need to have strong bullying and harassment policies in place that clearly set out what your company's stance is on the matter and detail how allegations of bullying and harassment will be investigated. We were talking earlier about if you were at a tribunal and you didn't have these policies, you'd really find it impossible to defend yourself. And that process of investigating it is really important, and it's important to show that you took all allegations seriously and that you dealt with them accordingly. Other policies that you kind of associated that you might also consider would be worth considering would be an equality policy and a dignity at work policy. And again, these will just clarify to employees what is acceptable behaviour and what repercussions there are in place in terms of if bullying and harassment occurs. And just to say that it's important when dealing with an allegation of bullying and harassment that the person dealing with it is cognizant that it is an allegation at that stage. But we'll move on from there. I think we're on to our helpline questions now.
Yeah, these are always very interesting. Okay, so...
Oh, apologies.
Okay. We've quite a nice slide here. It's very sneaky looking. But the GDPR, it's massively topical at the moment. And one of the questions we do get quite a lot is, can an employer share HR-related data with an external supplier of HR services without the consent of the employees? So let's say you're a bureau payroll provider and you have your contract with the employer. So the question is, can the employer share the personal data he holds on his employees with the third party being the payroll processor? And yes, absolutely. Now, the only thing you need to, be aware of is that the employer needs to inform the employees that their personal data is going to be processed by a third party.
Do they need specific, so they don't necessarily need specific consent from the employee?
No, they don't.
Once they've informed.
Exactly. So the information there, again, going back to the transparency, that the processing is done in line with the requirements of the GDPR. And the employer doesn't need the consent of the employees to share their data with that third party, but they obviously have to make them aware of it. Employers can allow third party, for example, a benefit supplier or an external HR consultant, to process data on their behalf only where the third party implements sufficient technical and organisational measures to comply with the GDPR rules and protect the rights of the employees. There must be a contract between the employer and this third party setting out specific details relating to the processing, what they're processing, how it's being processed, and the security measures that third party will have in place to ensure their compliance with the GDPR.
This is a really important point, actually, just to go off topic. It's the whole responsibilities that data processors have under GDPR. And as somebody who is outsourcing a certain amount of processing to an external or a third party, the responsibility is on you to ensure that that company is GDPR compliant or has made as many steps to be GDPR compliant. So what you really need to be doing is that if you are, we've done a GDPR webinar from a bureau point of view, but assuming we're talking to employers today, you would want to be putting, you need, as Jenny said, you want to be sure you have a good contract in place between you and your payroll bureau, for example, and there's certain information that needs to be in that document. It's processor agreements, a certain information in relation to data protection. We actually have one on the website, a template one. Now we've come at it from a payroll bureau point of view, and that will be the person that you're using, your third party, but it's up on the website. It's available. We possibly might include it in the follow-up email to today's webinar, just so you can have, and equally if we have bureaus on today's webinar, although the responsibility is with your clients to ensure you're GDPR compliant, we will be saying to you equally that, act as a guide or, educate your clients and tell them that this is being put in place, and you could certainly go to them and put this agreement in place. And we see it as an addendum to your current agreement.
Exactly.
Your current contract.
And although, we're dealing with it on a daily basis, we do still come across customers on the phone who kind of question, what is GDPR? So it's an opportunity for you to kind of, garner a good preface, and possibly new business by, kind of displaying or being able to show your compliance relation to the GDPR as well.
Yeah. Perfect. Okay. We have a couple of slides left, so I'm going to go through them because there are lots of questions as well. So we'll definitely get to your questions by 12 o'clock and we'll spend some time going through as many of the questions as we can. One of the questions as well that we come across is it permissible for an employer to terminate or to dismiss an employee on the grounds of ill health? I'm going to say yes, it is. Lack of capability, including ill health, is potentially a fair reason to dismiss somebody under the Employment Rights Act. And I say, yes, it is fair to dismiss somebody with big warning signs and flashing disclaimers as I say that.
However.
There's a big however coming. In order to dismiss an employee due to ill health, you must show that you've acted reasonably, both in treating their illness and being cognizant of the fact that they are ill, and also in ensuring that you have adopted a fair procedure in order to reach that dismissal stage. So when an employer is considering dismissing an employee on the grounds of ill health, as I said, you really should investigate it fully. So part of this this could be a long process. It's not something that you decide, well, Mary hasn't been with us for the last 3 months because she's sick, I'm going to dismiss her and we'll write that letter now. It's a process and it will take some time. Part of it will include consultation with the employee. It's really important. And we get this question a lot, is if someone's off on long-term sick leave, as an employer, can I contact them? Yeah. Yes, you can, absolutely. And
communication is absolutely key in that instance.
It's paramount, yeah. So certainly. Communication is key with long-term illness, and getting the employees' feedback and their ideas on, well, can you return to work? When can you return to work? Getting their opinion on it. Is there an adjustment needed to their role? What would work in order for you to return to work? So you getting as much. You don't have to take all their suggestions or ideas on board, but you have to be seen to be considering them and taking time to process them and fully consider them.
And include them in the process.
Yes.
Do you know what I mean? And not be making kind of these decisions and then contacting them to say, it's not working.
Yeah. They need to be part of the process.
Yeah.
The medical investigation, again, paramount. You would never ever dismiss somebody if you had on ill health if you hadn't got medical, got a medical opinion, and certainly in some cases 2 medical opinions, and depending on the case as well, we would often say an occupational health advisor is useful. So again, it'll be important in part as your part of your absence policies or your sickness policies that you include that, and you include a clause to say to employees that we may ask you to attend a medical investigation. Investigation doesn't sound like a good word there. A medical examination or a medical opinion in some situations. And then, the third point here is to consider alternative employment. Could the individual's role be adapted? Could they be moved from the warehouse into the office? Could it be changed, broken down different days? Could the time, I worked with a company before, and we just had somebody, she had really, really bad back pain. It was an office job, but she couldn't travel into work because it was London, and she couldn't manage the tube in rush hour, just with standing in the tube on her back. And that was a valid illness that she had. So we changed her hours of work so that she wasn't travelling in rush hour on the tube across London. And that was the alternative arrangement made in that situation, and it worked out quite well. So you just have to be seen to be thinking outside the box, I suppose, and looking at all the options available to you. But definitely when we talk about ill health, dismissal should be the last resort, and you should be able to demonstrate that to a judge. So I think that covers that. Just before we finish that, if you do dismiss somebody and you don't go through the processes that we've very briefly discussed here, you leave yourself open to an unfair dismissal claim, and possibly even a disability discrimination claim, if their illness was considered a disability, and we know that disability claims are uncapped when we go to a tribunal. Exactly, so again, costly if you get it wrong. Okay, The disengaged employee, the unfocused, the underperforming employee, it's just, they can sap the life out of any business. And I can't tell you how many calls we get from customers saying, so-and-so isn't working out, they don't care anymore, what can we do? We just want to get rid of them. And it's a difficult call to take because that, again, that generally that manager or that employer wants them gone yesterday, and that unfortunately can't be done generally fairly. Certainly, as you mentioned, capability and conduct, so can be fair reasons for dismissal again, but employers should be very cognizant of the fact that dismissal should only be carried out as the last resort, when all other avenues have been exhausted. So dealing with an underperforming employee needs to be, again, approached as a process, and it's not something that you're going to fix overnight. The key points to remember when dealing with these, I want to say lackluster, underperforming employees, again, is similar to the illness, is communication. So often, again, we come across the manager, the employer, who have an issue, but they're afraid to deal with it head on. And unfortunately, in this situation, it's the only solution is to talk to the employee. As a very broad and general guide, we're going to suggest the following steps, but again, it's a broad and general guide, and every case will be different. So the first one is to be open and honest and to give feedback to the employee that their performance is not meeting expectations. Of course, delivering negative feedback is never going to be easy, but a bit of preparation and have your facts in order can help. You want to establish what the cause of the underperformance is, so get to the root of the issue. Again, have you made your, is their workload too high? Is there something happening in their family life? What are the reasons? It could be possible other reasons caused for underperformance could be that you hired the wrong person for the job, and this would, again, highlight the importance of reference checking. That again, there may be personal influences that are affecting them. It might be a short-term issue that actually you can help them with. Childcare issues or something that you can work around and help the employee with. Ineffective communication can be one of the reasons for poor performance as well, when genuinely they don't know exactly what is expected of them. So clarifying them, and that communication is really important. The next thing what you want to look at is to create an improvement plan. So clearly outline to the employee what is expected of them. Be sure they are clear about the gap between their performance and what is required. Agree a review time frame. You might meet once a week for the first month, then have a full review after 1 month, and then have regular feedback. And it'll be important for the employee to be sure to give them sufficient time to actually demonstrate that they can improve. Outline where you can support the individual as well. Maybe that's extra training that you sit down with them every evening at 5 o'clock to go through the day. You need to be seeing that you've made steps as an employer to help them as much as possible. Also, be clear with the employee what will happen if their performance does not improve. And I've seen that in cases where employers have gone through lovely performance management processes and it just doesn't work out, and maybe it is a dismissal at the end of the day. But at no point was the employee warned that failure to improve will result in dismissal. And it's a simple line if you're issuing a letter to an employee in a performance management. It's a very simple letter just to include that line, failure to improve will result in moving up the disciplinary process, final written warning, or whatever it is. But it's a really important line to include. And that leads me on to the final point of having a clear audit trail. Ensure everything is documented and you have the correct letters in place. And I think Jenny is going to talk about letters later on. And then again, having done all that, having communicated, having given the feedback, having seen is there any reasons that you could help, having putting in a performance plan. If at that point you still have no improvement, then you're instigating the disciplinary process, as I said, and moving towards a disciplinary proceedings and dismissal.
Absolutely. And just as Laura said there about, going through the whole process and everything being perfect, and not kind of saying this could lead to dismissal, falling at the last hurdle. The same can apply to your trail, your paper trail. If you go through the whole process of sitting down, having meetings with them and don't document them, the same thing is going to happen. So don't do that and fall at the last hurdle. If you're going to go to the trouble of the whole process, make sure you document it properly.
And that's one actually that comes up on the phones, and when we get the call in, oh, well, I met with Johnny last week and I told him this, and well, did you make a note of that? No, I didn't. Well, you might as well you're just starting from scratch.
It never happened.
It never happened. So even if it is an informal catch up with the individual, just make a note of it, make reference to it. It doesn't have to be anything formal, but it's a note that say, I sat down with the employee on the 10th of April and we had this discussion.
And even I kind of noticed from talking to people, even though it's an informal meeting, by you actually sending on that email and just kind of, reinstating what's already been said, just kind of makes the employee kind of question, sit up and listen, go, oh, actually, weren't you serious about this? So no harm.
Yeah. Perfect. Okay, so we've talked monitor and give feedback. We talked about that. So we've covered a huge amount really in the last hour.
Absolutely, yeah. So we're just going to recap briefly on some of the key points that we've discussed, and we're going to highlight to you now how BrightContracts addresses some of this legislation. So just give me 2 seconds while I bring up the software. So Jasper. Contracts. Okay, so the first one we want to look at there is the fit for work assessment. Okay, so in BrightContracts, within the handbook section, we have got an absence policy. Now there's been changes there, obviously, that we discussed in relation to the fit for work assessment no longer being applicable from the 31st of March. And you'll actually see there, my yellow bar across the top is indicating to me that an update to the handbook content is available. And if I select the option there for more info, it's telling me what we've changed. So we've amended, the government's fit for work assessment scheme has now been scrapped. The absence and sickness absence policy has been amended to remove reference to that scheme. So if I go into my, let me see, where are you moving? Okay. If I go into my terms and conditions, here's my absence and sickness policy, and basically what we've done is we've just removed any reference in relation to the fit for work assessments from that. So any kind of legislation changes we will automatically update within the software. The gender pay reporting that we looked at there, we have built into the system an equality policy, and it's really one of those kind of highly recommended policies that you should include, and it's a very robust policy that we've actually included in there. It has the responsibilities of the employer, the different structures that are in place, your review and your monitoring systems that you have in place as well. So it's a very good policy, so there's no harm in having a look at that, or certainly including it within your normal staff or company handbook. And then the termination payments, we looked at the increase to the weekly pay.
And the pay in lieu notice.
Sorry, the pylon scheme. So
it's probably best to look at the contract. And I know there was a question came in there. There's lots of questions coming in on pylon. So PILON, it stands for pay in lieu of notice. And we're talking about the end of the employment contract here. And generally, this is when termination is happening, perhaps when not in the best terms, leaving and parting company. So somebody has either handed in their notice and you don't want them to work that notice, so you want them out of the door that day, or equally you're dismissing somebody having gone through a disciplinary process and you're saying you're ending today and we'll pay you in lieu of notice. So it's so that they can finish today, but again the statutory notice will still apply, so the pay in lieu of notice will just allow them to legally and contractually physically leave your employment that day, but be paid in lieu of working their notice.
That period, exactly.
Hopefully that kind of clarifies it. Up until now, there was an argument to say not to have that contract, not to have that clause in your contract, because by not having it in, you could pay a pay in lieu of notice tax-free. Now, as we looked at the start of this webinar, it's irrelevant whether you have a clause in your contract or not.
Yeah, it's all taxable.
It's all taxable. So it really is kind of best practice to put that clause in the contract now,
it gives the employer that little bit of extra flexibility where, in the unfortunate situation, you don't want somebody coming into the workplace causing an atmosphere or creating, issues or questions with other
Yeah.
staff members.
Yeah.
You know, so it's a good one to be able to
or having access to all that confidential information. You just want them out the door and they don't have time to get it. I'm slightly going into the questions because I've been keeping an eye on the questions. And just before you go on to the next point there, Jenny, somebody's saying, you know, how often should you be reviewing your contracts? And if you don't have this pile-on contract clause in your contracts at the moment, can you put it in? You should be reviewing them, I suppose, your contracts regularly. You don't have to do it overly regularly. Default employment law will always be the default employment law. Every couple of years I kind of recommend just to keep them up to date and change them. And certainly you can renew existing employees. I said Jenny's been with the Source 20 years. She's had several variations of contracts as things change. And that's just good practice to keep it updated and keep it relevant. And you know, you're not going to be changing the basic terms. But it's something like a pay and lieu notice clause. I think that's really for the benefit of both employees and the employers.
Exactly.
So I don't think that would be a clause that would cause much disagreement.
No. And just on that note as well, actually, we do get questioning quite often on the phone from people who feel that they need to issue a new contract every 12 months. That's not the case unless you've actually got a specific term contract with an expiry date on it. Your contract could be in place. As we said, I'm here nearly 20 years. You know, you could have the same contract there for 10, 15 years. Once there's no changes to the terms and conditions of the employment for that individual, that same contract is going to apply. You know, but as Laura said, it's just best to review it you know, for both parties to make sure that you're up to date with.
And then just the final point of this total aside is that obviously legally it's 2 months. You must provide a contract within 2 months of an employee starting employment. We do come across employers every day that have never put a contract in place. It's never too late to put a contract in place, even if you've passed that 2 months. You know, HMRC or, you know, the employment legislation will want to see you've tried to put the wrong right and fix it. So it's never too late to put your contract in place.
No, absolutely not.
So sorry, we've gone off there. So we were on termination payments.
Okay, so there's your payment in lieu. So the payment in lieu of notice, we default it, you know, so it basically includes the clause within the contract there, and that's in the miscellaneous section of the contract itself. We touched on...
But it can be removed just by unticking that button.
Sorry,
and you can,
yes. Any of those fields there can be...
And then that clause won't be included in the contract, but as Jenny said, we defaulted.
Exactly. It's best practice, folks. So we touched then on the bullying and harassment. So if I do say so myself, we have a very good bullying and harassment God, I'm going blind now. Clause or policy within the actual handbook. And it details, you know, what is classed as harassment, sexual harassment or bullying. And the procedures. And the procedures are really, really useful for both parties, both the employee and the employer, to kind of know, you know, what steps need to be taken to hopefully, you know, come to a positive resolution without the need of it going any further.
Yeah, I think that's what the handbook to me is really good, particularly for the small employer who doesn't have that dedicated HR department. Having this handbook in place, it's almost like a go-to guide. You know, hopefully bullying and harassment isn't something that's going to be landing on your desk all the time. So your managers, your line managers aren't going to be familiar with this kind of thing. So by having a handbook there, it's the go-to guide for them. So they say when this does land on their desk, they can go and they can look at the relevant procedure, whether it's bullying and harassment or perhaps maternity. What do I do in this situation? And these policies almost take you through as a guide as what needs to be done.
Exactly. And as we kind of touched on earlier on, you really want to be kind of showing a non-tolerance, you know, from the get-go, and hopefully then you won't come to any of those. Finally then, just in relation to that bullying and harassment,
kind of into disciplinary,
you know, kind of areas, with the BrightContracts software, as well as the software and the ability to be able to create and customize your own contracts and handbooks. We also give you access to a huge amount of online documentation and HR kind of help for you. So we've got the likes of sample clauses and things like that, but we have, in relation to that kind of disciplinary section there, template letters that can be given to employees at the different stages of your investigation procedure. You know, and it's a really useful tool that we've included within your contract with us as that kind of software provider. You do get all of this additional information as well, the likes of FAQs. We have a huge amount of information there in the GDPR, template letters, sample clauses, etc., etc. So just bear that in mind as well. And then I think that's pretty much it then.
Just gone back to
GDPR.
just gone back to the slides there, Jenny, if you can.
Sorry, yeah. This one and this one.
Yeah, so perfect. So these were the points discussed, and I said Jenny's gone through gender pay reporting, termination payments, we've just looked at bullying and harassment. The final one is the GDPR, and we've talked about how important it is now to review your employee data protection policies and your employee privacy policy. BrightPay, we've got these, we've written template policies for this at the moment, and I have them sitting there ready to go. What I'm waiting on now is my IT team to just change the software around a little bit. But there will be, there we do have GDPR compliant employee privacy policies almost ready to go. And the software will change slightly because the privacy policy will just be a new tab. You'll be familiar with, as Jenny's just gone through the software, 3 tabs across the top. We'll have a new tab and privacy policy, and in there you can create your employee privacy policy that contains all those key terms that need to be in it, and communicate that to your employees. That'll be really useful just for our users to know you have those GDPR compliant policies. So I'd expect them to be there. Well, they'll be ready by the end of the month.
Yeah.
But if you're interested, if you're not a BrightContracts user and you're interested in knowing when they're available, just let us know at the questionnaire at the end of that as well. That brings us to an end of our slides, and we've kind of gone slightly over, but we've been answering questions as well, so I think we're okay.
Yeah, we're not too bad.
There's loads of questions coming in. Just before we get to those questions, just really briefly, with GDPR, if you haven't actively signed up to our newsletter, we won't be able to contact you anymore because you won't have actively subscribed. So please do, hope you find the webinar useful and you enjoy the newsletters, etc., that you receive from us. Please subscribe, and you can always unsubscribe at any time as well. So we're just getting the questions then, but just to say we're having a 10% discount off BrightContracts. It's £99 per 12 months for a standard, and there's a 10% discount for the month of April. So Jenny's just opened the questions. We're going to try and finish by 12:30. We'll try. There's a lot of questions, so hopefully we'll get to as many as we can. Just one that I'm seeing coming up straight away. Gender pay reporting, how and where does one report these figures? You have to report your again, it's just for employers with over 250 employees, make that clear first. You have to report it in 2 locations, on your own website and on a government website. So gov.uk has guidance on how you report it there, and there's different reports that you need to report. There's all different kind of medians and then reports in relation to bonus. So there's guidance on the gov.uk website, and we also have some information on it on our own support page. So if you're on the brightpay.co.uk website, in the online documentation we have some notes on that there as well. BrightPay can provide you with 2 reports that will help you towards being, producing your gender pay reporting, but we can't because of the different terms and the bonuses, and some people call bonuses different things. It's not possible for us to have one just report that you process and click, yes, here's the gender pay reporting. So they're in our analysis section in the BrightPay software. There's 2 reports that will give you a lot of the information. You'll need to export them out to Excel. Again, there is a link. Actually, maybe we'll link that link
back to that. Yeah,
in the email. We'll send everybody an email after today's webinar with copy of the recording. I'm going to put in the DPA that we talked about earlier, the data protection, the data processing agreement, but I'll put a link to this the BrightPay support documentation for gender pay as well, so that'll be useful for you.
Somebody's asked there in relation to sick pay. If one earns £8.75 per hour and contracted to work 20 hours a week, how much sick pay could one claim for a week if sick? The employee has to meet the eligibility criteria. They have to be earning now £116 a week. So going forward, it has to be £116 a week in the relevant period, which is, I think it's 15 weeks prior to the actual sick pay period itself. So that's a statutory payment from HMRC themselves. And once the employee qualifies under that criteria, then they'll get the statutory sick pay figure, which I think it's gone up to 145 something now from the 6th of April.
Another one there, do we have to, the GDPR question, do we have to get consent from existing employees? No. So as we kind of said, consent won't work from employees anymore. So you're not going to rely on consent. What you're going to be relying on for processing data is other lawful reasons, such as the contractual reasons, such as the legal obligation to pay them. But you have to inform. It's not getting consent from employees, it's informing them what you do. So it's really important to get your employee privacy policy out there to employees. You don't need them to sign it and return it. Obviously, having a paper trail in some form is some way to show that you've given it to them, and actually that's where Connect would be really useful, because we have the document upload feature in Connect. So if you were to create a privacy policy in BrightContracts and then upload it into Connect, and Connect has an activity log that will show you who has read and when they opened it. So that could be a useful way of having your, I say paper trail, your online trail,
yeah.
But you don't effectively need consent or signature.
Okay. Confidential. How long should we keep information regarding unsuccessful applicants? So Laura touched on that. There is no legislation in relation to recruitment.
No, but you think about how long somebody might take a claim is what I'd be thinking of here. So there's no legislation that's going to guide me, but I think a claim could be taken up to 6 months. I'd probably keep it for a year.
Yeah.
That would be generally my kind of thinking. So you just need to decide what you're going to do, what you're going to do, and then put that in place. Somebody asking for the slides. Yes, we'll give you a copy of the slides. Oh, sorry.
You've asked us.
I think we did pile on. Yeah, that's the one I answered. What if the employee disputes information held by the employer? Well, that'll be all going back to your privacy policy. So again, this is a GDPR question. Somebody is saying, what if an employee disputes the information held by the employer? So you'll be relying on, why are you holding that information? Right? What are your lawful grounds for holding that? Is it for contractual reasons? Is it to a legal obligation to pay them? You know, is it in the business interests? Is that any other legitimate reason we talk about when we talk about GDPR? So that's why it's really important to put your reasoning in place. And it could be that maybe the employee has a valid reason in some instances, but definitely the importance of your privacy policy and clearly explaining why you're holding data. I didn't want to come on the GDPR webinar. There is extra criteria in relation to special categories of data, and here we talk about health data and biometric data. So some of that data could be under questioning, but maybe it would be good to check out our GDPR webinars where we go into detail on those pieces.
Yeah.
Okay, we're just going through. Sorry, there's a lot of questions coming in now. Okay, bear with us now. Apologies.
Okay, somebody's asked there, if an agreed salary deduction to repay a small loan puts someone's weekly wage under the minimum wage for that week, is it okay to proceed with the deduction? If it's an agreed deduction, you're reducing the gross pay. So the agreed gross is still above the minimum wage. That to me would be fine. Now, I'll have to double check it.
I would have to double check, because I'd be afraid that it wasn't, you could say, well, they got that loan early, they got it in advance, but shouldn't the minimum wage cover the period in which it was paid and which it was earned? So yeah. I would...
You need to look into that, I think.
I would be a little bit concerned about that one. We have somebody saying here that we mentioned premium for working unsociable hours. And so you're based in the north, in Northern Ireland, and you have employees who travel to England for whatever reasons. So that could be early finishes, etc. Yeah, this is an interesting one. We pay standard days plus flat rate. Sorry, it's a long question. Actually, we might come back to that one just separately because it's a long one too.
Quite detailed.
Yeah, so sometimes the questions we get in are quite detailed for just, we'll come back to you, Ian, if you don't mind. How long should ex-employee data be kept for? Again, you'll be taking guidance from legislation. You want your payroll data for 3 years, so it'll be 3 years after they leave. Pension records will definitely be longer. Health and safety records will definitely be longer. Think about your performance records. You might not necessarily need them for quite as long because, again, you think about how long an employee can take a claim, so you may decide 12 months for those records.
Somebody's asked there, can an employee claim statutory maternity pay and wages, not kit days? I'm assuming there that would be down to the employer, and if the employer has like a payment.
But can an employee claim SMP and wages? I don't think you can claim unless you're topping up.
Topping up, yeah, sorry, that's what I mean.
Yeah.
If the employer has in place a policy whereby they top up their wage to what it would normally be, that's down to the employer. There's no obligation on them to have to do it, and in most cases most employers go with just the statutory maternity pay, but it can be topped up if they wish to as well. If there was a case of bullying in the workplace but the person who would normally deal with it is a family member of the victim, what would you recommend doing? You need to be...
Sorry, I'm reading that one now.
Yeah. Be best to get a third party involved.
It could well be best. Yeah. This is a difficult situation for small employers when you have, the tribunals will take allowance that you are a small employer and you don't have those other levels of management or other departments to be involved. It is a family member of the victim. Yeah, I'd be inclined, is there another employee, or it may be a third party. Might not necessarily have to be a HR consultancy. It could be a business acquaintance.
Could be your accountant.
Yeah. But I think it would be
kind of outside the realm and not, kind of privy to the goings on. Yeah.
Do we have any updates on holiday pay regarding overtime? Would BrightPay will never, we don't calculate holiday pay. Holiday pay is, it's a topical issue, and obviously, what is included in holiday pay will, it's been in the news of late is that overtime is a commission, so it'll be very much dependent on each situation, I think. So BrightPay doesn't calculate it.
It doesn't calculate it. No, you have to enter in the figure yourself, or else have a rate set up for the hourly pay. There's so many different scenarios. There's no way that we'd be able to cover them all from a programming perspective, and obviously employers may have their own kind of breakdowns on it as well. So no, it is something you have to input yourself.
If employee, I think reading this one, if you got rid of an employee, how long before we re-employ? Well, I suppose that depends on why, the reasoning you got rid of them. And if they were dismissed for capability or conduct, then you could re-employ straight away. If they were dismissed for redundancy reasons, you might have to wait a little bit longer if you were to re-employ, because why was the redundancy? The argument would be, was it a redundancy situation at all? Yeah. So you would have to consider that. Although if it was a redundancy situation because you relocated, well then certainly you could re-employ straight away. So I suppose it depends on what the reason for the dismissal was.
Exactly, yeah. Somebody's asked there, is the handbook available in the BrightPay connector or the normal BrightPay? The handbook is on our BrightContracts software, so it's a separate piece of software to BrightPay and the Connect. It's basically a piece of software that enables you to create and manage your employment contracts and allows you to create and customize a company or a staff handbook. So brightcontracts.co.uk. You can have a look, download it there.
When an employee is being made redundant but being paid pile on pay in lieu notice for a few months, what is the effective date of leaving? The last day they worked or the end of the pile on period? The last day they worked.
Yeah,
it's the last day they worked. Okay, so let me see.
Right. BrightContracts is available as a bureau. We have a standard version for single employers, and we have a bureau version for bureau practices as well, to be able to do them for their clients. Oh, somebody just paid full price for contracts in March. Sorry about that, Jason.
Oops. We have an employee who's a home worker. We pay for their travel time. Does this count as a taxable benefit? Oh, well, I'd have to pass that to a pensions person. That would be from an employment point of view. We'd have to double check that one for you.
Yeah.
The bureau for BrightContracts is $199. We have a lot of bureaus who use it as a kind of a nice
add-on.
You know, you can charge for it, and we have sample documentation to help you charge and offer it as a bureau service. But it's a nice value add, I suppose, if you're running payroll before somebody, and then you're able to just add on a new contract when they bring in somebody new. It can be useful. And Elaine, if you're interested in a full demo, we'd be happy to arrange that as well. So I think that's actually, we've kind of got through. There's a couple of questions I know, Ian, and a couple of people that we need to get back to on a couple of questions, and we will do that later today. But that brings us to an end. So thank you all very much for your attention. I hope you found it useful. As I said, we have a few things to put up in the follow-up email, so we will include those bits of information for you, and we'll get that out hopefully this afternoon, if not.
And don't forget, just on the questionnaire at the end of the webinar, just if you do want to continue receiving our newsletters and things, you can register for it on the questionnaire at the end.
Yeah.
Just include your kind of consent and your email address there.
Perfect.
All right.
Okay. Thank you very much, everybody.
Thanks, guys.